so we'll just be hearing from Attorney Kelly in case number 29204, State of Ohio versus Robert Hanford. You'll have 15 minutes, and we've read the briefs and are prepared to proceed if you are.
Okay. Thank you, Your Honors. May it please the Court, Attorney Angie Kelly on behalf of the appellant Robert Hanford. The issue for the Court's consideration today that I would like to discuss first would be that the defendant did not have effective assistance of counsel pursuant to the Strickland standard in this case. Understanding that it is a two-prong and that it means that he fell below the standard of care, as well as that there could likely have been a different result, the appellant wishes to assert a position that if none of the individual issues that we raised in our brief and that we will discuss are sufficient to rise to that standard, that when taken in culmination, that they would rise to the level of being below the standard of reasonableness. First and foremost is that there was no request for a jury instruction for voluntary manslaughter. It's our position that under the facts of this case, that a jury instruction for voluntary manslaughter would have been warranted. It is not a lesser included offense of murder, however, it is an offense of inferior degree, meaning that it is given the same test and whether or not it should be included. The fact that counsel didn't even request it when we're dealing with a circumstance in which there is an admission to the act that caused the death of another individual, when we have aggravating facts that meet the code of the statute, we feel is insufficient and fell below the standard of reasonableness for an attorney.
Counsel, you talk about an admission to, which there was in this case. I think it actually was a self-defense argument.
Correct.
Not necessarily inconsistent with getting the manslaughter charge, but you talk about the aggravating facts. What was it? Not the facts, but what in the record points to your client's mental state at the time of the incident that would warrant that charge, even if been requested by trial counsel?
In regards to his mental state for his being, I'm assuming the court is referring to that he's in an agitated state, right? That he was.
Well, I don't think the statute says agitated.
Well, I believe it says that he has to, I recognize that there is not a lot of information in regards to him being in an extreme,
Yes.
I'm trying to think, I'm sorry, I'm having a failure on the word here, I know what the language is.
Yes, sudden passion.
Boom, that would be
I
it.
didn't help you because I was
like-
hoping you would say it.
Sudden passion, I was like, I'm sorry, I just blanked on that. In regards to sudden passion, I would say that primarily that would be a derivative of the defendant's own statements, and that he awoke into somebody who was strangling him. I think that would be sufficient to induce anyone, and if the jury believed it, that it would rise to the level of I need to defend myself. Not only was it that he woke up to somebody choking him, but he clearly stated that he made attempts to get away in a non-violent fashion, and that those attempts were thwarted by the decedent continuing to attack him. Outside of that, though, there is some evidence that was produced by the state in regards to him being a little bit angrier earlier in the evening, but it was at different individuals, so I don't know that it would be applicable to that instance.
Thank you.
Trial strategy always comes up on these types of arguments. How would you, what would your argument be against that? You know, this was just trial strategy on the part of the defense counsel.
Well, I would say that the trial strategy does always come up in these arguments, and that it's something that the attorney had to determine whether or not they thought was more appropriate to ask for or not. I would say that in this instance, and under these facts, especially since he's asserting a self-defense claim and not denying anything, that he should have more of a duty to present any and every option. And I believe if you look back through the record that there was initially a voluntary manslaughter option given as a plea offer to the defendant in this case, which to me would give some indication that the state felt as though there may be a manslaughter fact pattern here that the defendant or appellant had chose not to avail himself to, and I feel like that put counsel in a position where he should have reapproached that as an option outside of trial strategy. So outside of that, We also feel that he failed to rise to the standard of reasonableness by not bringing in any type of an expert in regards to the behavior of the defendant at the time. And I read the state's brief, and I understand there is some law and he would have had to tread carefully because of the mental state not necessarily being admissible. However, I suppose what I would add to that argument is that he didn't ever have him tested for his mental state either. Perhaps that could have been some kind of a defense that could have been presented, and it was never done. It's very clear from the record that the appellant's behavior was a bit abnormal after the series of events that took place, with him going to the neighbor's house and not speaking and just removing his shoes, and then kind of in a daze. And then going to the other neighbor's house and not necessarily recalling or understanding what had happened, but saying, call the police. Every officer that came on scene, every officer that testified, which was like 6 or 7 of them, all 3 of the lay persons that were neighbors, all of them gave testimony indicating that this man appeared to be in a daze, almost in what I would say is a state of shock, although there's no medical expert. As someone who practices in court often, I hear that and I think, oh, well, maybe he was having some sort of a shock reaction, but that's outside the province of the jury. That is not lay information, it's expert information. And then none of that information was presented because a huge part of the state's argument was that his inconsistent stories are the reason that he's guilty and that you can't believe his self-defense claim or his testimony. However, the mental state could also go to that as a defense. The reality is if he was in some sort of a shock situation as a result of stabbing his lifelong friend, perhaps the memory comes back in pieces and parts. Those are things that an expert could have helped the jury to understand, that they weren't given that opportunity because there was no information presented to them on that. The third position that we feel was a problem is the video of the cross-examination of his confession. The prosecutor spent a substantial amount of time cross-examining the defendant, quoting this video that they fought like crazy to keep out in their case in chief because they wanted the officers to be able to give their summary, which the law supports. They get to choose. We take no issue with that. But then once you turn to cross-examination, if you're going to spend page upon page questioning and quoting from a video that was recorded over a year ago without having any opportunity for that to be presented, to show whether or not we need to rehabilitate him, whether we can refresh his recollection, I feel like they opened the door to this information coming in that they tried to keep out. And although I did not find any law directly on point, it seems to me that it's fundamentally unfair to argue that somebody's lack of recollection during a traumatic event is impeachment material when you can't rehabilitate. His attorney made no attempt to rehabilitate, and the state pointed out in their brief that it wasn't proffered and it's not part of the record here, so we can't even review it. And I would say that supports our position that was another mistake made by the attorney. At a minimum, when the court said that this tape was not going to come in, this confession that was recorded on the day of the incident should have been proffered so that everybody could review it at further date to determine whether or not there was an error there, and that never took place. Because that video also would contain video evidence of his state of mind at the time of the offense. So we feel that those issues taken together show that his attorney did not rise to the standard of reasonableness, and that it is likely that there could have been a different result, particularly as it pertains to the mental state of the appellant, since that was not presented.
Counsel, as to that tape,
Yes.
when did trial counsel try to admit the tape at any point in the proceedings?
Trial counsel tried, I guess you would say, to
Let me say use the tape at any point in the proceedings.
in his case in chief, he did not. When the officer was called to the stand to testify in regards to that, trial counsel raised the issue and asked the court to require them to play the video, as opposed to having just the officer testify as to their summary of what the statement was. Trial court denied that, citing case law, which we feel is proper. Case law does indicate that it is within the purview of the prosecutor whether they want to go one way or another with the video or. However, then once the prosecutor spent excessive time impeaching with it, it's our position that he should have raised that in order to be able to rehabilitate and or then introduce that into the record as evidence, and he failed to do so.
Your client testified, correct?
He did.
Could it have been played during his testimony if there was something that needed to be corrected?
Correct. I believe he could have been rehabilitated with it. This- 5 minutes. The second one that we would like to raise, at least briefly, Your Honor, is the manifest weight, as we feel as though the jury lost its way and that the appellant did in fact prove self-defense by preponderance of the evidence. One being he had no duty to retreat as he was living in the home that the incident took place, that he was not at fault. The defendant testified that he woke up to being strangled, he didn't start the confrontation or the affray, and then he had a bona fide belief of imminent danger and he could only escape by use of force, which is factually a little bit repetitive to what we talked about. Same thing, that he said that he was afraid when he woke up under those circumstances. He was kind of shocked because this is a lifelong friend, he didn't understand why he would be attacking him. He attempted to leave by moving down the hall and was unsuccessful with that attempt and felt that the only way he could get out would be to utilize the small pocket knife that he carried on him at all times. So we feel that he did present that by preponderance of the evidence, and therefore the jury lost its way. And I think just briefly in closing, I would just note for the record that in regards to the sufficiency, we would stand by our arguments. I did make a typo and put appellant instead of state in the standard. However, the argument still pertains. Our argument is that in the light most favorable to the state, that there was not sufficient evidence of knowledge on his part in order for that charge to go to the state. And if there are no other questions, I would rest on my brief. Thank you.
Thank you very much for your argument, and take the matter under advisement and make a decision in due course. Of course, the reports will mail you a copy of the decision on the day it's released.
Thank you.
Thank you for your argument.